private dining suite at Carlisle Sinclair on Bay Street had seen oil executives, cabinet ministers, and at least 2 future prime ministers pass through its door, but it had never seen a man in a security uniform stand at a whiteboard in front of 40 lawyers and say, "Watch me," to a sitting appellate court judge. Dr. Christine Barlow had placed a certified check for $500,000 on the mahogany table and told Adrian Reeve that she was prepared to make it simple. He had looked at the problem written on the board and answered with 2 words, and the room had gone entirely quiet in a way that nobody standing in it could have predicted 3 minutes earlier. Why that silence fell the way it did is where the story actually begins. 3 blocks north on Queen Street West, inside a courthouse building that had not changed its stone face since 1829, Adrian Reeve had worked the main security desk at Osgoode Hall for 8 years. He arrived at 7 in the morning, left when the building locked at 6, and drove home in a 2009 Civic he maintained himself because the dealerships in the city charged what they charged. He was 52, with the kind of face that courthouse regulars passed 100 times a year without committing to memory. That suited him. The guards who worked alongside him knew the basics. They knew he had a daughter in her 2nd year at Queen's because there was a photo of her taped inside his locker. A girl with his same careful eyes and a laugh that looked like it cost her nothing. They knew he took lunch outside regardless of the weather, because no one had ever seen that precedent broken. They knew he was quiet without being unfriendly, and that when young articling students got lost in the building's older filing systems, they ended up at Adrian's desk without quite knowing why. What none of them knew was that 19 years earlier, Adrian Reeve had been on the short list for a Supreme Court appointment that did not happen, because by then it was already too late. At 33, he had argued 2 landmark charter cases before the Supreme Court of Canada. At 35, a senior partner at his firm had moved $500,000 through a client trust account using Adrian's access credentials, and when the Law Society began its investigation, the partner had a documented paper trail prepared. Adrian had spent 4 years fighting it. He lost. He had done bookkeeping for a construction company in Hamilton while the appeal moved through channels. He had done pro bono contract work for a legal aid clinic in Scarborough. He had taken the position at Osgoode Hall because it was inside the law and at a respectful remove from it, and nobody there had ever read a law review. The law had not left him. It sat where he had put it, the way a house you grew up in still stands after you have moved out. He simply stopped opening the door. The night everything changed, Graham Sinclair had reserved the private dining suite at Carlisle Sinclair for what his office called a salon dinner. Sinclair ran a private equity group from the 42nd floor and was the sort of man who decided the evening's terms before the first car arrived. His guest list ran to 40 names, 14 senior lawyers and judges, 6 law professors, a former justice minister, and the rest drawn from the kind of wealth that prefers engraved invitations to press releases. Patrick Kellner, the venue's events coordinator, told his staff twice that nothing was permitted to go wrong, and then called in a favor from Adrian to cover the building's service entrance, because the regular liaison had broken his wrist 2 days earlier. Adrian was not catering. He was there because Kellner had once resolved a parking matter involving his daughter's first car, and debts of that kind mattered to him. He wore his uniform, managed the service corridor, and kept the freight elevator clear. Christine Barlow arrived at 7:45 in a charcoal blazer, and the room adjusted around her in the particular way of rooms that know who they have been waiting for. She was 38, held an endowed chair at Dalhousie Law School, and had been appointed to the Nova Scotia Court of Appeal 6 months earlier. Sinclair had seated her near the center of the long table on purpose. At the far end sat Reginald Barclay, 71, a retired justice from the Ontario Court of Appeal, who had clerked more than 30 students over a career built on precision and very little patience for approximation. He had said almost nothing all evening, which in a room full of lawyers was itself a form of statement. By 9 o'clock, the dinner plates had gone, and the whiteboard had come in on casters from the boardroom suite upstairs. Sinclair stood, tapped his glass, and announced that the entertainment portion of the evening would now begin. It started easy, a statutory interpretation question, a charter problem that a professor from Osgoode dispatched in 4 minutes. The lawyers were performing for the money in the room, and the money in the room was paying exactly for that. Christine took the marker at 9:30 and wrote a jurisdictional question in administrative law. She solved it herself in 7 minutes with the ease of someone who had prepared both the question and the answer, which she had. Sinclair led the applause. A professor named Nathan Ford said something about the elegance of her approach that was mostly about Nathan Ford. Adrian came through the connecting door to confirm the dessert timing with the catering lead and stopped 3 feet inside the room. Not from any calculation, he had simply read the board. He read it the way he had once read factums under fluorescent light in a Hamilton office, first for the structure, then for the joints. There were 2 problems. The first was not minor. He waited until Christine had stepped away from the main table toward the drink station, 4 feet from him, out of earshot of the room, and he spoke at the register he used when advising guests that an elevator was temporarily out of service. The solution treats the enabling statute as spending the tribunal's jurisdiction entirely. Dunsmuir changed the standard of review, not the jurisdiction. The conclusion is correct. The path treats 2 distinct legal concepts as the same one. Christine looked at him, the uniform registered first, then the words arrived behind it. "I'm sorry," she said. "What is it you do here?" He told her. He said he did not mean to interrupt. He turned to go. That would have been the end. He was nearly certain of it afterward. But Vivienne Cross, a commercial litigator from Adelaide Street, who had been sitting within earshot, said with the lightness of someone accustomed to establishing facts, "Did the security guard just correct her argument?" The room turned, not all at once. It moved in a ripple, conversation dying from the center outward, 40 faces finding the same 2 people standing at the drink station. Patrick Kellner appeared in the service doorway, with an expression Adrian had never seen on him before. Christine Barlow's face did something controlled and quick. Adrian watched a woman decide in under 3 seconds what kind of person she was prepared to be in the most professionally significant room she had stood in during the past 6 months. And the decision she made was not to check the board. "He has," she said, and walked back toward the whiteboard and let the room's attention follow her. "He's flagged the jurisdictional analysis. For those of you working in other areas, jurisdictional error and standard of review error are related concepts in Canadian administrative law." She drew a dividing line and labeled each side, related, not identical. Someone near the window laughed. Sinclair leaned back with the stillness of a man who has just understood the evening is going to give him more than he paid for. "I want to be fair about this," Christine said, her voice staying level. "Curiosity about the law is genuinely valuable. There are textbooks. There are continuing legal education courses, most of them open to anyone willing to register." She turned and looked at Adrian fully. "What there is not is a version of this discipline where 8 years of standing at a courthouse entrance is equivalent to 8 years of legal training. That is not snobbery. It is what the bar exam costs. It is what 30 years of court filings cost." Adrian said nothing. He had placed both hands behind his back and folded them there, which was what he did when he needed his body to stop broadcasting anything. Vivienne Cross asked mildly whether anyone had actually established whether the original observation was correct, or whether they were all simply enjoying themselves. Nathan Ford said, with the confidence of someone who rarely waited to be invited, that in his experience people who corrected specialists at social occasions were usually correcting their own misunderstanding. "He said the path doesn't work," Christine said. "Not the conclusion, the path." She paused. "Do you understand what a specific thing that is to say? It is the vocabulary of someone who has heard argument analysis discussed. It sounds precise. It costs nothing to say." The temperature of the room settled against the wall where Adrian was standing. 40 people. 2 of the catering staff had stopped in the doorway. Kellner was making a small motion with one hand, low, meaning come away now. "I'm going to do something," Christine said, and picked up the marker again. She wiped the board and began writing from scratch. This was not administrative law. What appeared was a constitutional question, layered with a paramountcy problem, and a peace, order, and good government argument assembled in a form that one of the law professors said quietly he had not encountered arranged quite that way before. When she stepped back, 2 sitting judges leaned forward. "This is the ceiling," Christine said. not the level I work at on a reasonable day, the ceiling. If the objection came from a real place, this is what that place looks like." Sinclair asked what she was proposing. She opened her bag without hurrying, produced a check already signed, and placed it face up at the head of the table where Sinclair sat. $500,000, Christine said. "Argue it tonight, in this room, orally, in front of everyone here. If the argument holds, the money is yours, and I will apologize to you in front of every person here." A man from a pension fund at the far end said her name once quietly. She did not acknowledge it. Sinclair read the check, set it down. He said he had watched confident people make expensive mistakes at his dinners before. Then he said he would personally guarantee the amount from his own account that evening, and she could settle with him privately afterward. "It isn't for you," he said when she objected. "It's so that nobody here spends an hour wondering if the check clears. If he wins, he's paid before the uniform comes off." He folded the check once and placed it in his jacket, and the room understood that the stakes had stopped being rhetorical. Christine turned back to Adrian. "And if the argument doesn't hold, you'll say out loud what this actually was. That you wanted the room's attention. That you saw 40 people who have spent their careers on something difficult and decided it cost nothing to take a swing at it." Her voice stayed level the entire way through. "Then you walk back through that door and finish your shift. That is the deal." Kellner stepped forward from the doorway and began to say that his staff were not part of the evening's program. Sinclair raised one finger barely, and Kellner stopped speaking because the man raising the finger had reserved the suite for the next 2 years. The room waited. Adrian was aware of every calculation available to him. He could apologize, step back through the service door, and the whole thing would be a story someone told for a month. He had built 8 years of a life small enough to carry without assistance, and everything in him that had learned to be careful was saying to protect it. But he had read the board. And the thing that had happened at 33 in a courtroom in Ottawa. The thing that had made a Chief Justice write in the margin of a factum that this was the clearest reading of Section 92 he had encountered in 11 years on the bench, happened again now, without permission and without effort. Sinclair asked him his name. "Adrian Reeve," he said. It was the first time that evening anyone in the room had asked. He crossed the room to the whiteboard, and the sound of his shoes on the hardwood was the only sound. He picked up the marker, turned it once to feel the weight, and read Christine's problem the way a man reads a face that belongs to a very long time ago. Christine asked him, with something that sat close to genuine uncertainty, whether he understood that there was no version of this that ended well for him. Adrian uncapped the marker. "Watch me," he said. He did not start at the top. The room noticed that immediately. He stood with the marker at his side and read the problem from the bottom upward, from the peace, order, and good government argument backward through the paramountcy problem to the division of powers frame at the foundation. To most of the table, it looked like a man stalling in front of 40 professionals. Nathan Ford said to no one in particular that hesitation was usually diagnostic. At the end of the table, Reginald Barclay sat with one hand flat on the surface and said nothing. Then Adrian wrote a single paragraph of argument, not an introduction, not a heading. The core of the federal position in the division of powers dispute, stated without preamble, with the peace, order, and good government clause held in reserve as a secondary ground, because using it first was the error every second-year student made, and more than half the senior lawyers in the room had made it at least once. Barclay stood up. He walked to the end of the table to get a direct line of sight to the board and stayed there. Adrian kept going. The lines came steadily, not fast, each one shorter than the professors in the room would have written it. He was not laying out the connective tissue. He was showing only the joints, the places where the argument turned, and letting the straight sections take care of themselves. Ford leaned toward Christine and said something. She did not respond. She was watching the board with her arms folded, and the expression on her face had not changed since as Adrian picked up the marker, which was itself a kind of information. At the 4-minute mark, Vivian Cross asked if anyone could explain in plain terms what was happening on the board. Barclay answered without turning around. He said the man had reduced the problem to its constitutional skeleton and was arguing the bones in proper sequence, and that he was not yet certain whether this was precision or a category of error he had not encountered before. Adrian reached the halfway point, stopped, recapped the marker, and studied what he had written the way a man checks a load-bearing joint. Then he uncapped it, drew a line through one of his own steps, and replaced it with something shorter. "He's working from general principles," Ford said, louder now. "He knows the concepts. That is not the same as knowing how to argue them in a room that matters." Nobody agreed out loud. That was the moment the room changed, and everyone in it felt the change before they could have described it, because the argument on the board was not decorative. It obeyed every constraint Christine had written into the problem. 3 of the lawyers at the table had begun verifying lines in real time. Adrian finished at 11 minutes, set the marker in the tray, and turned around. He did not underline anything or step back for effect. He put his hands behind his back the way he had all evening and waited. Barclay went to the board. He read it once at pace and again carefully, running one finger under the 3rd line and then the 7th. When he finished, he took his glasses off. "It holds," Barclay said. "It is also 3 moves shorter than the approach I would have recommended, and I have been practicing and teaching constitutional law since before most of you sat a bar exam." He walked to the other half of the board, where Christine's original administrative law solution still stood. He read that as well. "While I'm here," Barclay said, "the conclusion was correct. The analysis treated jurisdictional error and standard of review error as interchangeable. They are not. That was the man's original observation, and it was accurate before any of this started." The room produced a sound that was not applause. It was the sound 40 people make when they have been corrected about something they did not know they were wrong about. Christine Barlow crossed to the board. She read Adrian's argument once quickly and then again with her full attention, and arrived at the same place Barclay had. "It's a clean structure," she said. "The problem I wrote has a natural factual pattern that makes the division of powers argument more available than it would be in a harder case. He found the path of least resistance. That happens. Graduate students find it and then spend 4 years learning that legal argument is about what you do when that path isn't there." She turned to Sinclair. "One argument is not evidence of anything. You wouldn't trust a surgeon off a single procedure." Sinclair said he had twice, and that both times it had been the right call. Ford said the fair thing, the rigorous thing, was a proper sample, not one problem selected by one person, a set drawn from actual cases by the lawyers and judges in the room, with no advance preparation possible. Christine agreed before Ford had finished the sentence. Adrian could see exactly what that agreement cost her, and chose not to look at it directly. What followed in the next hour did not resemble a dinner. Sinclair reorganized the room with the efficiency of someone who ran 2-hour board meetings. A second whiteboard came down from the boardroom suite. The lawyers and judges were asked to submit problems from their own practice. A man from the pension fund appointed himself timekeeper. 4 problems went up over the next 50 minutes. The first came from a commercial litigator who had spent a year on a contract dispute that had settled before trial. Adrian resolved it in 8 minutes, then told her, without adjusting his tone, that the difficulty had probably come from reading the exclusion clause in isolation rather than against the whole indemnity structure, and that if she read the contract as a single document, the apparent ambiguity disappeared. She sat down and did not speak again for 15 minutes. The second came from Ford, written slowly, concerning the application of an evidentiary rule to a criminal trial hypothetical. Adrian looked at it for longer than anything else that night, and then said he could not resolve it. The room reacted to that more strongly than to any of the correct answers. "I can't resolve it," Adrian said, "because the hypothetical contains a factual impossibility in the second paragraph. The chain of custody described is not legally achievable given the timeline established in the first paragraph. If the evidence was collected the way the problem says it was collected, it cannot also have been logged the way the problem says it was logged." He took the marker and wrote the discrepancy out in 4 lines. Barclay came forward again, checked the sequence on the back of his program, and confirmed the counterexample stood. Ford said the hypothetical had come from an actual case. Barclay said that errors in the record were how appeals were won, and that this was a reasonable thing for a man who had worked in a courthouse for 8 years to have noticed. The third and fourth problems went the way the first had. By the time the fourth concluded, the character of the room had inverted entirely. Lawyers who had arrived intending to perform for the investors were now asking Adrian questions between problems the way you approach a specialist you have just discovered at a conference. A retired federal court judge asked him which unanswered constitutional question he considered the most practically significant. Adrian answered him squarely and briefly, and then crossed to the sideboard, picked up the water pitcher, and refilled the glasses of the three people nearest him, because he had noticed they were empty. Nobody in the room knew how to process that detail. Sinclair said it was the most disorienting hour he had spent at one of his own dinners. Christine Barlow had stopped speaking. She was standing near the second whiteboard with a glass she had not touched in half an hour, and she was not watching the board anymore. She was watching Adrian. The way he held the marker between problems, low and loose, the way people hold something they have used long enough to stop thinking about, the way his eyes went to the water glasses before anyone asked. After the fourth problem, she said quietly, to no one in particular, that a man did not develop this in a security booth. Vivian Cross asked what she meant. I mean, he had a career before this, Christine said. Someone trained him. Someone spent years on him. Her jaw moved slightly, and now he is refilling my water glass. That was the closest she came, and she walked away from it almost immediately, because Ford had pulled her aside near the window, and when they came back, he was carrying a leather document folder from the coat check. Ford announced they had one more problem, not from any published source. It came from a factum he and Christine had been developing for 14 months in connection with an intervention application not yet filed, seen by exactly 3 people, all of them bound by professional obligations. He wrote it on the board. It took 6 minutes and covered the surface. Barclay read it and said flatly that it was not a fair problem. He said what was on the board was 14 months of careful legal thinking, not an after-dinner exercise, and that whatever they believed they were establishing, this would not establish it. Sinclair asked Adrian whether he wanted to stop. The honest answer was that he had wanted to stop 2 problems ago. Something he had put away deliberately and kept away with real discipline for 8 years was now standing in the middle of the room with all the lights on, but he had read the board. I'll look at it, Adrian said. What followed was not like the first hour. Christine did not sit down. She stood 4 feet from the board and challenged the first line before Adrian had finished writing it, asking him to justify the constitutional basis for the standing argument. He justified it. She asked why the standing argument survived a mootness challenge. He answered that too. Ford took the left edge of the board and questioned every procedural step from the other direction, and between them they turned every line into a defense, and Adrian could see, behind the questions, the architecture of something prepared in advance. 20 minutes in, Ford said the word. He said it carefully, as a hypothesis raised in the spirit of professional thoroughness, which is how these things are always said. He said he would like to understand how a person with no legal credentials moved through a 14-month factum as though he had read it. The man from the pension fund said what half the table had been calculating. He asked whether the security guard might have access to the firm's document management system through the building's shared services network. It was a reasonable question. It became what reasonable questions become in rooms full of lawyers when money is sitting in someone's jacket. Someone else noted that the dinner had been on the calendar for 6 weeks, that the guest list had circulated, that building security would have had advance notice of the event. Adrian kept writing. It was the only available response, and he knew it. He wrote and answered and wrote, and every third line he had to stop and explain to a room of lawyers why a step he had taken for granted since his early 30s was permissible. He was 5 lines from the end when Christine moved. She stepped between him and the board, not making contact, and turned to face the room. Her voice was completely steady, and Adrian understood watching her that she had been building toward this for the past 10 minutes, and that the questions had never been entirely about the law. Stop, Christine said. I want everyone to look at the peace, order, and good government construction in the 4th paragraph. Barclay said the paragraph was sound. It is sound, she agreed. It is also the precise construction Nathan and I developed in March, not equivalent to it, the same construction, with the same three-part test arranged in the same sequence with the same evidentiary threshold. It has never been filed, never been presented at any conference, never been published anywhere. Adrian set the marker in the tray. He could have said the obvious thing, that any constitutional lawyer who approached that problem from first principles would arrive at the same three-part construction, because it was the only logical object the problem made available. That the structure was not exotic, it was necessary. That the reason their unpublished factum was worth writing was precisely because the argument was inevitable, and any competent practitioner would build it inside a day. He knew it. He could have demonstrated it in 6 lines. But he had been in a version of this room once before, 19 years ago, when the evidence assembled against him was also technically consistent with more than one explanation, and he knew what a room sounds like when it has already finished deciding. Vivienne Cross said, carefully, that she would like to establish whether anyone had actually investigated the access question before the conversation continued in its current direction, because someone appeared to be approaching a serious professional allegation against a person who had not yet said anything false. The man from the pension fund said the money was in Sinclair's pocket and suggested it remain there while the matter was looked into properly. Patrick Kellner came through the service door fast, and this time no raised finger stopped him. He said what he had been holding for an hour, that a member of his staff was being publicly accused of professional misconduct in front of 40 guests, and that the event was concluding. He looked at Adrian and said quietly to come back through the service door and wait, and the way he said it was not unkind. Adrian looked at the board. 5 lines. He could see all 5 complete, in sequence. He could see the final one, the argument that closed the entire structure. He knew that if he wrote it, the case would be finished and undeniable. He also knew it would not matter, because the question in the room was no longer whether the argument was correct. He set the marker down, said nothing, and walked through the service door into the corridor, where the overhead light buzzed and the kitchen ran on the other side of the wall the way it always did. Indifferent, loud, completely uninvolved. He found the folding chair that someone had left against the wall and sat on it with his forearms on his knees and looked at the floor tiles. 8 years of being no one had been careful work. He had built it deliberately. It had held until the moment he looked at a whiteboard. And now, for the second time in his life, a room full of lawyers had agreed that he was a fraud. The door opened. He had expected Kellner. It was Reginald Barclay. The old man came into the corridor slowly, keeping one hand on the door until it closed, and stood with his back to the wall because there was only the one chair, and Adrian was sitting in it. "They're arguing," Barclay said. "Ford wants its records pulled tonight. Sinclair wants his dinner back. Nobody has looked at the board in 20 minutes, which is the only part of this evening I find genuinely offensive." Adrian told him he was grateful for what Barclay had said earlier, and that he understood it would not change the outcome. "Probably not by argument," Barclay said. "Arguments are what put you in that chair." He explained what he intended to do. There was one thing in a room full of lawyers that could not have been prepared for, previewed, or taken from anyone's draft. A problem that had not existed until the moment it was written. He would compose one himself, in front of the room, from material he had been developing privately for 2 years, and had never spoken aloud to anyone. If Adrian resolved it, every accusation on the table collapsed without anyone needing to concede anything publicly. If he did not, the evening ended exactly as it was already ending, and nothing would be worse than it currently was. Adrian asked him why he was doing it. Barclay considered the question longer than Adrian expected. "Because you refilled 3 water glasses in the middle of the 3rd problem," the old man said. "A man performing a deception does not do that. A man performing a deception is concentrating on the performance." They went back in together. The room had broken into clusters. Sinclair was standing with his phone in hand, not using it. Ford had the document folder open and was showing something to the pension fund manager. Christine Barlow stood alone near the far window and turned when the door opened. Barclay did not ask permission. He walked to the center of the room and stopped. "Before I do anything else, I want one thing said in front of all of you, because it should have been said 30 minutes ago and I was too slow." He looked at Ford, then at Christine. "Your peace, order, and good government construction is not exotic. It is the necessary object. Any constitutional lawyer who works that problem for 2 days builds it, because it is the only structure in the vicinity that does what the problem requires. The two of you know that better than anyone in this room, because it is the reason the factum is worth writing. What happened here tonight was a man arriving at the only available argument and being told he must have stolen it." Nobody answered. Ford looked at the folder. Christine looked at nothing. Barkley walked to the second whiteboard and erased it completely with 3 long strokes of his sleeve. Ford said his name sharply. "Sit down, Nathan," Barkley said. And Ford sat, because there are still a small number of people in any profession who can produce that effect with 4 words. Barkley explained to the room what he was going to do. He would compose a problem now in this room, from an idea he had been carrying unwritten for 2 years and had never spoken aloud to anyone. Ford and Christine were welcome to watch his hand form every character. If anyone could explain how a man steals something that did not exist 60 seconds ago, he would be interested to hear the mechanism. Nobody offered one. Barkley wrote for 7 minutes. He wrote slowly, with an old man's handwriting, and the marker was audible the entire time. When he finished, he stepped back and offered no commentary on the difficulty. He did not need to. The reactions from the lawyers in the room were the commentary. The commercial litigator said quietly she would not know how to begin. The retired federal court judge said it was less a legal problem than a research agenda. Ford studied it for a long moment and said nothing at all, which was the loudest confirmation available. Sinclair asked how long a strong group should expect to need. Barkley said a serious seminar could make progress in a semester with sustained effort. Christine spoke for the first time since she had made her accusation. She asked Barkley whether he knew the answer himself. "No," Barkley said, "that is the point. I can verify an argument. I cannot supply one." He held the marker out toward Adrian. The room turned. Adrian took it. He read the problem. Then he read it again, and something happened that had not occurred once in the entire evening. He felt the full size of it. Barkley had written something with no available handhold, no recognizable structure, no familiar argument that fit. He understood within 90 seconds that none of the tools he had used all evening would work here. He stood in front of the board without writing for 4 full minutes. Someone near the window whispered that he was finished. Ford said nothing. Adrian noticed the silence, and the noticing mattered because it meant Ford was watching properly for the first time all evening. At 4 minutes, Adrian set the marker in the tray, walked to the long table, picked up a linen napkin and folded it once. Then he came back and used it to clean a section of the board in the corner, about 2 feet square, and began writing there instead. Not at the top. In the corner, small, in a notation that reorganized the question from the ground up. Barkley moved closer. Adrian was not arguing the problem, he was translating it. He was encoding Barkley's question as a statement about something else entirely, a framework in which the original difficulty was not a difficulty at all, but a consequence of a principle already well established, if you were prepared to look through the right frame. Barkley put his glasses back on. The commercial litigator moved to where she could see the corner of the board. The retired federal court judge moved. Then 2 more, and within 5 minutes there were 9 people standing in a half circle around 2 feet of whiteboard in a room that had stopped being a dinner party hours ago, and none of them were speaking. Adrian kept going. The translation took 18 minutes. The argument on the other side took 11. He covered both boards and had to erase a section of his own earlier work to reach the final line. He wrote it, capped the marker, set it down, and stepped back. And for the first time since he had crossed that room, he let his breath go. Barkley read it the way he had once read factums before rendering decisions, once at pace, then from the beginning, working through every line, and it took him 17 minutes, and the room did not move. Twice he stopped and asked Adrian a question. Both times Adrian answered in 2 sentences, and Barkley nodded and continued. When he reached the end, Reginald Barkley turned around to face a room of lawyers, investors, and judges. "It's correct." Nobody moved. "I want to be precise," Barkley said, "because precision is the only currency I have left worth spending." He did not solve what I wrote. He dissolved it. He found a framing in which my question becomes a routine consequence of something already known, and I have carried that question for 2 years and never saw it. I have clerked 31 students. I have sat on 3 courts. I have never watched anyone do that in a single evening. He took his glasses off and placed them in his breast pocket, and he looked at Adrian rather than at the room. There is one more thing, and I would rather say it than leave you all to speculate about it on the drive home. 20 years ago, there was a law society proceeding that resulted in a disbarment. The name in the file was Reeve. I was not on the panel. I was told the matter had been handled properly. He stopped for a moment. 7 years ago, I sat on a review panel examining the same file under new disclosure rules. We found that the access credentials had been used from an IP address that placed the senior partner in the building at the time of the transfers. The disbarment was overturned on the record. The finding was sealed by agreement because the firm was still operating. The room was completely still. He was never told, Barkley said. The Law Society sent the notification to the address on file, an apartment he had left 4 years earlier. He has been working 3 blocks from my office for 8 years, and it took a public humiliation to get him back in front of an argument. He let that stay in the room for a moment. I would like every person here to sit with that. I intend to. The applause started near the window. It was not the applause the room had produced at 9 o'clock when Christine had set down the marker after her solution. This went on long enough to become something else entirely. Sinclair was standing. Vivian Cross was standing. The man from the pension fund had his hand over his mouth. Adrian did not acknowledge it. He was looking at the floor near the base of the whiteboard, and his hands, now that they were empty, had begun to shake. Nathan Ford left the room through the main door. He did it quietly and did not come back. Christine Barlow stayed. She stood in the same position she had occupied for the past hour, and when the room finally went quiet, she was the only person who had not made a sound. Everyone understood what was owed and who owed it. The silence was harder for her than anything louder would have been. She walked to the head of the table. "Give it to me," she said to Sinclair. He took the check from his jacket and placed it in her hand. She held it and looked at it. Then she looked up at Adrian from across the room. "I said tonight that standing at a courthouse is not equivalent to a legal education. Then I accused you of theft. I did it because I could not construct any other explanation for what I was watching, and I would rather have been managing a dishonesty than facing the alternative." Her voice did not break, and that made it harder to listen to. "The alternative is that I was wrong about who you were from the moment you opened your mouth, and that everything after that was me defending the mistake instead of examining it. Justice Barkley checked your first observation in 90 seconds. I had a full hour before I wrote that problem. I never looked." She crossed the room and held the check out to him. $500,000 in front of every person here, exactly as promised. The apology as well, also exactly as promised. I want the record to reflect that the apology is not for losing." Adrian took it. He looked at it for a moment, folded it once, and placed it in the breast pocket of his security jacket. And that detail, the uniform still on, the building pass still clipped to the lapel, was the thing that several of the people in that room would describe to someone else within the week, and would still be trying to describe years later, because they could never find a simpler way to say what it meant. "Thank you," he said, "that was all." Christine waited for something more and did not get it. Adrian understood that the absence of it was the only grace he had left to offer her, and he gave it without ceremony. What happened in the hour that followed was compressed in his memory afterward. Cards came across the table. Sinclair made an offer, no title specified yet, because the title would come after the work was defined, and he would build the definition around whatever Adrian chose to focus on. A judge asked whether he had considered a reinstatement application. A retired senior partner from a Bay Street firm said the climate for such matters, given what was now on the record, was considerably different from what it had been 19 years ago. A man he had never met asked, without any performance in it, whether his daughter was aware of what her father had spent the past 2 decades navigating. Adrian said she was not, fully. The man said she should be. He thanked all of them. He accepted nothing that night. Reginald Barkley was the last to leave. He put on his coat at the door with the deliberateness of a man who has decided to stop being in a hurry. "They'll all call you tomorrow," Barclay said. "Most of them want to say they knew you first. 2 of them want the work." Adrian asked which 2. Barclay told him and then left. Patrick Kellner found him afterward alone in the private suite, collecting water glasses from the tables because the catering staff had been dismissed and the glasses were still there. Kellner told him to put them down. Adrian said it was his section. The 2 men stood across from each other in a room with 2 covered whiteboards in it, and Kellner said that he had spent the whole evening trying to manage a situation and had been managing entirely the wrong thing. He said the position was there as long as Adrian wanted it. He also said, with the honesty of a man who ran a business, that he did not expect that to be very long. Adrian gave notice the next morning. He worked his remaining 2 weeks because he had committed to the shifts and other people would have had to cover them. He did not take Sinclair's offer. The money was considerable and the work would have sat inside someone else's structure, and he had learned at 35 exactly what it costs to give a piece of your thinking to an institution and hope it comes back to you intact. He took one of the 2 that Barclay had named, a research position at a law school in a city with a reasonable commute, with a written agreement that he would select his own questions, no teaching obligation attached, and no announcement made. The old man was listed as a consulting collaborator on the first paper. Barclay insisted on second position in the byline and would not be moved on it. The check cleared. He moved his daughter's university payments off the line of credit and called her the same evening to tell her, properly, what the last 20 years had actually contained. She was quiet for a long time on the other end. Then she said she wished she had known sooner. He said he had spent 20 years wishing the same thing, and they left it there for the night, because some things need a little time before they can be set down right. He found an apartment where he did not have to calculate parking into every decision, and started working in the early mornings again, for the first time in 19 years, at a desk beside a window with decent light coming in. The message that came out of that room was not complicated. Several of the people who had been there spent the year that followed rearranging something in the way they conducted themselves in rooms that held other people, in ways they would not all have been able to name precisely if asked, but that showed up quietly, in small and practical ways. Never measure a person's capacity by the door they are posted beside, the uniform they are wearing, or the desk they were hired to sit behind. Knowledge does not require an introduction. It does not wait to be recognized. Set it in front of a problem that nobody prepared for, and every assumption in the room will correct itself, without being asked, and without any help at all.